I'd like to welcome, who is going first? It's Cordiana Cozier, who's going to talk to us about the Sixth Amendment in the age of data, how sovereign AI can restore constitutional capacity in public defense. Cordiana.
Good evening, everyone, and thank you so much for being here. My work asks a simple question, which is what happens to constitutional rights when the volume of digital evidence far exceeds human cognitive capacity? Today, public defenders are expected to sift through mountains of data with limited resources, while often managing hundreds of cases at the same time. My proposal explores how sovereign AI systems could function not as replacements for lawyers, but as constitutional infrastructure, tools that restore the practical meaning of the Sixth Amendment in the age of data. Carol Brooke, a longtime public defender, once noted that this work isn't for money. There isn't enough. Don't do it for the prestige. You won't get any. Don't do it for the thrill of victory. Victory rarely comes. Do it for love. Do it for justice. Do it for self-respect. Do it for the satisfaction of knowing you are serving others, defending the Constitution, living your ideals. But even the most dedicated attorney is hitting a structural wall. We have a system where prosecution activity expands through digital tools, but defense resources remain fixed. When defense capacity collapses, the costs are felt in rushed plea deals, mass incarceration, and a loss of democratic legitimacy. Now, within the Constitution was included the Sixth Amendment that guarantees the right to counsel. But the Constitution was written for a paper-based legal system, and today, criminal cases are data systems. A single felony case may include dozens of hours of body camera footage, phone extractions, surveillance video, and digital communications. Meanwhile, public defenders handle over 100, sometimes over 400 cases annually. Under those conditions, constitutional rights become constrained not by legal theory, but by cognitive bandwidth, and that changes how justice operates. Now, psychological research shows that chronic cognitive overload changes decision-making. Under stress, people rely more heavily on heuristics. Attention narrows, and bias becomes more behaviorally influential. Now, legal scholar Song Richardson calls this triage justice, a system where time scarcity rather than legal merit determines how cases are handled. This matters because most criminal cases never go to trial. Over 90% are resolved through plea agreements. So when defenders lack the time to fully review evidence, constitutional violations may never even be identified. And more importantly, this is not merely a problem of individual attorney performance. It transforms constitutional protections into probabilistic outcomes. The right to counsel exists formally in every case, but in practice, its effectiveness varies according to time pressure, workload, and the complexity of the case. Two defendants charged with identical offenses may receive fundamentally different levels of defense simply because one attorney had 40 cases while the other had 400. In that sense, the Sixth Amendment begins to function less like a fixed guarantee and more like a resource that degrades under institutional strain. This load is worsened by linguistic barriers. Standard transcription methods frequently misinterpret African American Vernacular English, or AAVE, which is spoken by over 80% of African Americans. Consider Warren de Mesme, who told police to give me a lawyer dog when he was brought in on suspicion of a crime. He was not granted a lawyer and later confessed to the crime. Now, his lawyer stated that his confession was not legitimate because he was not granted his Sixth Amendment right. However, because of dialect misrecognition, the court argued that his request was equivocal, suggesting that he might have been asking for a canine lawyer rather than invoking his Sixth Amendment rights. When lawyers are cognitively depleted, these are exactly the type of biases that lead to a structural denial of due process. Now, you might argue, okay, Cordiana, this is just one example in many examples, and this might have just been an extremely prejudiced judge. But these problems extend beyond isolated courtroom examples. Consider this mistranscription from testimony given in Jamaican Creole. The speaker stated the original statement up here, and it was transcribed into, "When I heard the bop bop, I dropped the gun and then I started to run." But the accurate translation was, "When I heard the bop bop, I dropped to the ground and then I started to run." That single mistranscription completely changes the meaning of the testimony. In the original version, the speaker appears armed. In the correct version, he's taking cover from gunfire. And that distinction can fundamentally alter how a jury, prosecutor, or judge interprets the case. This highlights a broader concern as well, which is that speakers from marginalized linguistic communities are more likely to be misunderstood, mistranscribed, and potentially criminalized because their speech patterns are treated as deviations rather than legitimate forms of communication. And so how can a closed-loop sovereign AI system help with the risks that I've proposed, or the problems that I've proposed? Well, imagine a public defender receives a case containing body camera footage, surveillance videos, dispatch logs, interview transcripts, and cell phone extraction data. Today, much of that review process is still largely manual. In this proposed system, all of those materials would be first securely ingested into the local environment within the defender's office. The AI would then perform organizational tasks. First, it would synchronize evidence chronologically across sources. It could align timestamps, match speakers, and construct a unified sequence of events across multiple streams of evidence. Next, a computer vision layer would identify procedurally significant moments, such as when handcuffs are placed on, when a search begins, when emergency lights activate, or when force is used. And at the same time, a linguistic layer would generate dialect-aware transcript designed to reduce disparities in speech recognition, particularly in AAVE and other frequently misclassified dialects. This result would be what I have coined as a constitutional timeline, an interactive interface that allows attorneys to immediately navigate to legally significant moments across thousands of pages and hours of evidence. Now, you might be asking, okay, why can't we just use ChatGPT or an AI platform that's already available? And the reason is because confidentiality is a constitutional requirement. Cloud-based systems are built to extract data, which risks exposing privileged information. And furthermore, recent legal signals, like the ruling in USA versus Hepner, suggest that AI-generated documents may not always be protected by attorney-client privilege. This is why a sovereign architecture is non-negotiable. Like MIT's Parley tool, our system is locally deployed and non-extractive. It ensures that data never leaves the institutional control, aligning computing power with constitutional responsibility rather than commercial incentives. Now, to understand how this might work in practice, we can look at what occurred on June 4th, 2020 in Mott Haven, New York. On this night, there was a clash between the New York Police Department and protesters that resulted in hundreds of arrests. Now, the police narrative was that these arrests were necessary because there was a violent protest. But the truth was buried in over 6,300 fragmented video clips that consisted of social media posts, store surveillance, and thousands of hours of police body cameras. No single lawyer could watch all of that and analyze that data. It was a data haystack. However, researchers used a methodology that I'm proposing similarly for public defense. They created a digital twin of the neighborhood. By using AI to synchronize the footage, they matched the rhythm of a chant in one video to police sirens going off in another video, and they built a granular second-by-second reconstruction of the entire night. The results were undeniable. The synchronized data proved that the NYPD used kettling, which is intentionally trapping peaceful protesters in a confined space before moving in to arrest them. Because the technology could structure this fragmented data at scale, it led to a settlement of over $21,000 per person, which is the highest per-person payout for mass arrest in US history. This proves that constitutional violations aren't limited by legal theory, they're limited by our ability to see them within the data. Of course, systems like this also introduce real risks. And in public defense, those risks carry enormous consequences, so any implementation of a technology such as these would need to include strong safeguards. The first risk that I've identified is epistemic dependency, which is over-reliance on the technology itself. The fear is that attorneys may begin relying too much on what the AI flags and not going to investigate it for themselves. To mitigate some of this risk, the platform would be intentionally non-predictive. So it wouldn't say this search was illegal or legal, it would just say a search occurred. So it forces human verification at that step to go back and check. The second concern is the idea of AI monoculture. Today, attorneys bring different instincts, strategies, and specialties into their defense work. And if every office relies on the exact same AI system, you could argue that legal reasoning could become overly standardized. Future iterations of this technology should therefore allow customization based on jurisdiction, attorney preference, and case specialization. And finally, and most importantly, there must always be a human in the loop. The AI can identify the needle in your data haystack, but the attorney is the one that needs to identify whether that needle is worth using in court or not. So what I've proposed thus far is for the next 5 years, but thinking about the next 10 to 15 years and iterations down the line, I think that a great use of this technology could be for plea bargaining support. Since over 90% of criminal cases are resolved through plea agreements, defenders often make extremely high-stakes decisions under severe informational constraints. A future system could help attorneys identify sentencing patterns, charging inconsistencies, or negotiation outcomes across similar cases. And again, the system would remain completely advisory, not determinative. Its purpose would be to expand what attorneys' capacity is currently, not to replace their professional judgment. Now, our legal system today is built on the assumption of adversarial parity. That is the idea that the prosecution and the defense can both fully examine the facts of a case. But today, that parity is an illusion. Currently, prosecutors often have access to advanced forensic tools and centralized evidence systems. Meanwhile, public defenders are expected to manually review mountains of digital data under extreme time pressure and with limited resources. When one side can process evidence at scale and the other cannot, the adversarial system breaks down. This system is designed to close that gap and restore the balance. In closing, I want to emphasize one point, which is that doing nothing is not a neutral choice. If we continue to ignore how digital evidence has transformed the law, we will drift further into a system of triage justice, where constitutional protection is determined by a defender's workload, and where the most vulnerable defendants receive an inferior defense simply because their case involves more data than a human being can realistically process. As Barton and Bibas observe, technology and new approaches to dispute resolution have led us to the threshold of a new golden age of access to justice. Amazingly, it's already happening all around us. The question before us today is not whether legal information is accessible, we know that it is. The question is whether our justice system can keep pace with the scale of modern data in a way that makes our constitutional promises real in practice. That is the challenge this work is trying to address. Thank you so much for listening, and I'm happy to take any questions.
So, thank you, Cordiana. Questions? Kieran, you can lead off.
Thank you very much. I wanted to ask about the structural conditions that might drive the
Oh, sorry, my fault. How do I turn it on? Okay, try that.
Yeah, there we go. Thank you very much. I wanted to ask if you could say something more about the structural conditions behind the problem you're addressing. So the background issue is that prosecutors have a kind of resource edge, so there isn't parity with public defenders.
Right.
And there's a new resource you're proposing for public defenders. Are there reasons to be optimistic about how that parity will play out? Because presumably the prosecutors will also want and get access to AI, and then there'll be an arms race. But maybe there's reason to be less pessimistic about that? I don't know.
Yeah, absolutely. And that's definitely a concern I was thinking about when developing this idea, for sure. But I think the idea is less of taking from one side and giving to the other, of like Robin Hooding this whole situation. I think it's more so that to level the playing field in terms of caseload and like workload, being able to give public defenders the access to that AI system wouldn't prohibit prosecutors from doing the same, but rather would put them on the same playing field of allowing them to both have the same processing of data. But yeah.
Great. I have to say questions. Okay. Questions? Further questions? Yes.
So just today, I was reading something published in a foreign language, which I vaguely know, and so I wound up using Google Translate. But I know enough of the language that I was able to identify places where it's simply mistranslated. So in the case of the guy who was accused of having dropped the gun rather than having dropped to the floor,
Right.
I could easily imagine some AI system making exactly that mistake.
Yes. And that's definitely a concern with like original iterations of the AI that we would produce. I think that, sorry, I'm going to talk about my dad, but he did something similar with this in his job, where they were able to use multiple iterations of the technology by being able to appeal to native speakers of whatever language it would be, to be able to use them to train the model. I think that would be helpful, because even with like thinking about slang or like words that may not always translate exactly, being able to use someone who's more familiar with the language to have second and third iterations of the model to improve the language or like speech translation, I think would be useful.
Great.
I loved your talk. Thank you so much for this presentation. I'm curious if you've thought about the fatigue such a system may cause and a resulting disengagement as a majority of the prosecutor job shifts from creative crime solving and defending to a verification of a large amount of facts from AI.
Yes, that's definitely a great question and a great concern to take into account. I think that it would be a matter of redistribution of thinking about what the most energy is going into currently. And so if we think about building, or if you're going to have to go through all of this body-worn camera footage manually, and being able to identify that yourself versus this AI has flagged these different things that, yes, you have to go back and verify, but it's such a compressed version of that data that I still think it would be beneficial to have that as opposed to what they're currently working with now.
Have you thought about how this will interact with de-skilling? So we know that clinicians that use AI systems become de-skilled.
Yeah.
So they're not able to actually do the original job after using an AI system supportively. And obviously public defenders are at a huge disadvantage. They're doing all of this work, but they're able to do the work, right? And so one concern is that by saying the solution to this, resource gap is throw AI at the less resourced individuals, right? That they will lose the capacity to have those skills.
Yeah, that's a really good question. And I think that, so two things. The first is there was a case that happened recently where someone who was being defended felt that his public defender was not, or did not review his case thoroughly enough. And because of that, the public defender actually admitted that he wasn't able to give enough time. So it's like, yes, currently that workload is doable, but not so much under a system where the representation is at a great point. So I think that there's always a risk of thinking about how throwing the AI at the system might have people lose their ability to do that job. But I think right now, the way that I've envisioned this AI being implemented is less so about being able to predict whether something, or for the AI to have the jurisdiction over something, and more so for them just to be able to sort the data currently. And I don't think that that is a skill of public defenders right now that is completely necessary.
Great.
Hi, thank you so much for the presentation. I really enjoyed it. A quick question is, it's well known that for some of these models, actually due to the pre-training corpus, bias actually seeps into these models. Look at Gemini historically. So I wanted to ask you to say more about what you envisioned for human-in-the-loop oversight to prevent biases from trickling up to the layer and us just laundering bias into these seemingly neutral models, which might be dangerous.
Yeah, absolutely. So bias was definitely a concern that I had originally thought about just when thinking about, as you said, any AI system and incorporating it. I think that having, or once the model would begin to be built, thinking about having human verification or human in the loop at every step of that verification. So thinking about inputting in 10 hours of body-worn camera footage, having someone manually check that themselves, and then being able to go back and look at what the AI has flagged and whether that's being validated or not. And with the dialect-aware transcription, as I said before, having someone who's well-versed in whatever language that's being spoken to be included in that as well. I think would be helpful parts in getting it off the ground and getting better iterations made, is to always have a human in the loop at every step of that.
Thank you for your question, for your talk. So I had a brief question around the very idea of this kind of developing AI for under-resourced public defenders. So wouldn't it be the case that this will become the new tool for individuals, and then they will just be getting more work because they can achieve more with these tools, and essentially we will face the same problem again. We're seeing similar patterns in software engineering where people are expected to produce more because they have access to more powerful tools. So just your thoughts on this.
Yeah, I think that's a really great question, and points back to that a lot of this problem and similar problems are like these bigger systemic issues of even if their caseload is lessened, perhaps now they'll be having 700 or 800 cases as opposed to the 400 originally. I do think that with iterations of like starting it up and being able to have human verification, there will be more time allotted for that where they won't be able to have more cases. But I do think that it is a valid concern when thinking about what is the actual solution to the problem. I do know that there was a study done recently where they showed that even having increased amounts of public defenders doesn't solve the problem completely because of a similar thing. But I think that it would aid them greatly in their current state more than just increasing the number of public defenders and having them still have to go through the work manually.
Great. We have time for one last question.
Okay.
My last question will actually be related to the previous one.
Okay.
I'm wondering about the development and operationalization of such a tool, which presumably would be quite expensive.
Yeah.
And how do you think about the trade-off between exactly the opportunity to hire more public defenders on the one hand, and on the other hand, investing in such a tool?
Yeah, it's a really great question. And one that I thought a lot about, specifically because there's one technology that's similar to this. It's specifically based on transcription. It's called Justice Tech. But it's mainly being used currently by prosecutors because it's so expensive to like implement AI into these systems. And so I think that a lot of it would have to do with being able to rely on government funding for that. And I think that I still think that the trade-off in productivity would be greater, albeit more expensive, to implement an AI system like this rather than just hiring more public defenders.
Okay, give it up for Cordiana.
Woo!